Nee. Jessica. Yes. Jessica. Niet op de voorste rij, dat is het enige. Ik wil ze kunnen zien. Daar zie ik ze niet. Daarachter. Ik denk op de derde rij, maar daar zie je B en Elke nu. Nee. Sas. Zeg Jesus en Jess op de derde rij. Jesus en Jess op de derde rij. Sorry, ik vind B en Elke heel lief, maar... Nou, ik zie de mensen daar niet. Ja, ik wil ze kunnen zien. Oh. Dat vond ik bij Oor heel leuk, dat iedereen aan die kant zat. Maar het kan nu niet, dat snap ik. Maar... Ja. Nou, ik kan jullie dus niet zien, dat is echt super. Zelfs we moeten over 1 minuut beginnen. Ik weet niet waar Hannes is. Moet ik de microfoon gebruiken, denk je? Is die aan? Denk het wel. Goedemiddag, lieve mensen, lieve vrienden, familie, collega's van Anna. Ik ben Sascha, de paranimf. Ik ben hier, als het goed is, 1 minuut, waarin ik wat huishoudelijke mededelingen moet vertellen. En daarna zal Anna hier staan voor haar lekenpraatje. De ceremonie gaat ongeveer als volgt. Anna begint zo meteen met het lekenpraatje, duurt ongeveer 10 minuten. Dan hebben we even de tijd om daarvan bij te komen en dan komt de pedel binnen. Als de pedel binnenkomt is het de bedoeling dat iedereen gaat staan en mogen we ook niet klappen. We mogen gedurende de hele ceremonie niet klappen. En het is ook de bedoeling om de instructies van de pedel op te volgen. Dus als zij zegt dat we moeten opstaan en weer moeten gaan zitten. Ik wil u vragen om de telefoons allemaal uit te zetten. In ieder geval geen geluid. En de plechtigheid, dus de verdediging zelf, duurt precies 45 minuten. Van 2:15 tot 3. En daarna zal de commissie zich terugtrekken voor beraad. Waarna ze weer terugkomen en hopelijk Anna gaat promoveren tot nieuwe dokter. Daarna is er vanwege de coronamaatregelen een moment om te feliciteren. Maar zoals jullie allemaal weten is dat opgedeeld in tweeën. Dus er zijn 10 mensen hier aanwezig waarvan ik wil vragen om nog even te blijven zitten. En die kom ik dan na een kwartiertje ophalen. En de andere mensen die kunnen meelopen met het cortège en met Anna om te feliciteren. En dan nog het laatste over het mondkapje. Als jullie zitten mag het mondkapje af. Maar zodra we staan of heen en weer bewegen, dan moet het weer op. Dat was het. Veel plezier. Ja, jullie mogen niet klappen. Wil jij dat mogen ze foto's maken? Nou, ja. Het is niet erg als jullie foto's maken.
Er is een fotograaf alleen, dus het hoeft niet. Dear family, friends and colleagues, dank u wel, gracias, thank you for joining me here today, even if the circumstances are a little bit different than expected. To everyone watching the live stream, hello from Amsterdam to Exeter, Rome, Barcelona, London, Athens, Oslo, Hamburg, Brussels, Den Haag, Leiden, and many other exotic places. Those of you who have seen my book, or at least the cover of the book, may have wondered, why have I chosen this image? The painting is the blossoming apple tree by Mondriaan on display in the Gemeentemuseum Den Haag. And to me it represents life, strength, potential, which is my wish for the EU and its Charter of Fundamental Rights. It is colorful but abstract, with blurred lines and curves moving in different directions. The contours of the tree are still rough, like Article 47, which in my book I call a chameleon provision that may change color according to context. Article 47, the provision that has been the topic of my research for the past 4.5 years, lays down the fundamental rights to effective judicial protection for violations of EU rights and freedoms. It is an EU-wide provision, binding for all EU member states. But what does it mean in practice, especially for civil courts that have to resolve disputes between companies and citizens like you and me? What I have done in my research is mapping the role of Article 47 in practice. I've tried to find patterns by analyzing case law, and you can see the very long case law index at the end of my book. I could not look at all countries all at once. They have different legal systems, different courts, and different rules, which also shows the importance of understanding a national setting. And therefore I have focused on 2 countries, the Netherlands and Spain, which are opposite in the number of references to Article 47, low in the Netherlands and relatively high in Spain in the wake of the 2008 financial crisis. As Churchill famously said, never let a good crisis go to waste. In 2020, the silver lining of the corona crisis is that I get to have a hybrid Ph.D. defense, making it possible for more people to watch online. In 2008, there was a global financial crisis that led to an increase in court cases across Europe, exposing bottlenecks in the civil justice system that prevented people from exercising their rights or courts from protecting those rights. And that points to a lack of effective judicial protection, sometimes with harsh consequences. For instance, the burst of the housing bubble in Spain led to many people being evicted from their homes without courts being able to intervene. Many cases were about mortgage loans, consumer credit, or other contracts that contained unfair terms. And the problem was often an imbalance between the parties, not only in terms of bargaining power, but also in terms of legal remedies available to them, as well as the knowledge and financial means necessary to make use of those remedies. I focus on the Unfair Contract Terms Directive because it provided a gateway to EU law, Article 47, and the Court of Justice in Luxembourg. There has been a flood of cases, especially from Spain, and Spanish banks have become quite infamous as a result. On my visits to Spain, I recognized all of these banks from my research, and you will find their names in my case law index as well. There are literally hundreds of cases, but let's take one typical example. Imagine you buy a house with a mortgage from Bank X, and it could be any of these banks that you saw on the previous slide. The crisis leaves you without a job, and you fail to pay the mortgage for 2 months in a row. The contract allows for the bank to claim interest rates as high as 20% and early termination of the contract. And there are rules in place that make it possible for the bank to evict you out of your house only on the basis of a pro forma document without your signature. So what do we have in the balance here? On the one hand, we have the privileged position of the creditor and its interest in swift enforcement of the debt. And on the other hand, we have the need for judicial control of unfair terms, but also procedural justice. Both parties, the bank and you as a consumer debtor, deserve judicial protection, but what if the courts are sidelined and cannot provide any protection at all? Then the bank may get away with an infringement of your EU rights, and there is a denial of justice. And this is precisely the constitutional dimension of Article 47. It is not just about consumer protection against unfair terms under EU law, but it contains autonomous procedural safeguards. Potential problems may be that it's difficult or even impossible for you to go to court because it's too expensive, for example, or because the court may not be able to give the remedy you seek. The parties may not have the same weapons at their disposal. For example, if you cannot raise any objections against eviction, even if you would go to court. Or the court takes a decision without hearing unmuting the parties first. A violation of the right to be heard is often a complaint made by professionals when the decision is not in their favor. Article 47 can be invoked by both parties. Justice for both, which is also the title of my book, requires first of all a fair balance, which means that courts must take the position of both sides into account. But there are contrasting dynamics. On the one hand, we have individual rights protection, and on the other hand, the effectiveness of EU law, which is a tension inherent in Article 47. Article 47 on the one hand contains these self-standing safeguards that you saw on the previous slide, and on the one hand it emphasizes the link between substantive and procedural protection of, in this case, consumers. There is a disbalance that should be remedied between these consumers and the professional party. But the big question is, to what extent? In any case, my research shows that a reference to Article 47, this fundamental right, may signal a problem and the need for change. It's, so to speak, a fundamental rights alert. It indicates the seriousness of the problem and the urgency to find a solution, and contributes to the visibility of systemic issues and structural disbalances. My research also shows that the potential of Article 47 in this respect has not been fully realized yet in practice. There is a gap between theory and what the courts are doing. And what the courts are doing is also not necessarily aligned. The Court of Justice focuses primarily on effectiveness, while Spanish courts refer to the constitutional dimension, and the Dutch courts largely seem to overlook this constitutional dimension. Article 47 is indeed a chameleon provision, which brings me back to the cover of my book. It is a tree split in the middle of the book with branches on both sides. And as Eleanor Roosevelt famously said, justice cannot be for one side alone, it must be for both. Not justice for growth, but justice for both. A call for clear balancing of the different rights and interests involved and explaining why a certain path is chosen. And in the end, it is up to the courts to show Article 47's true colors. Thank you.
Dames en heren, ik heet u van harte welkom bij deze bijzondere zitting van het College voor Promoties van de Universiteit van Amsterdam ter gelegenheid van de promotie van mevrouw Anna van Duin. Mevrouw de promovenda, wilt u het eerste gedeelte van het formulier dat voor u ligt voorlezen?
Op gezag van de rector magnificus en het College voor Promoties aan deze universiteit zal ik in dit uur ter verkrijging van de graad van doctor mijn academisch proefschrift, getiteld Justice for Both, Effective Judicial Protection under Article 47 of the EU Charter of Fundamental Rights and the Unfair Contract Terms Directive, in het openbaar verdedigen. Allen derhalve die mochten verlangen tegen de inhoud van het proefschrift enige bedenkingen voor te dragen, verzoek ik dit te doen op een juiste en duidelijke wijze en aldus aanleiding te geven tot een geregelde gedachtenwisseling.
The opposition will be opened by Professor Cavaggi, Counsel of State and former Professor of Private Law and Comparative Law at the University of Trento and the European University Institute. Professor Cavaggi, a warm welcome to you. We are very pleased that you are joining us here today. You have the floor. Professor Cavaggi, could you please unmute yourself?
Thank you very much, Mr. President. Dear candidate, I would like to open the discussion by asking you to highlight what, according to your thesis, are the substantive and procedural factors that explain the differences between the impact of EU case law, the Court of Justice case law on Spain and the Netherlands.
Highly esteemed opponent, thank you for your question, which actually goes to the core of my PhD thesis, which is indeed a comparison between the impact, so to speak, of the Court of Justice case law in Spain and the Netherlands and why it is received so differently. The first factor that I see from the perspective of effective judicial protection in the context of this specific directive and consumer protection is that Spanish courts seem to have much less space, this is a procedural factor, in the proceedings to actually apply consumer law ex officio, but also the ambit of the dispute or the scope for judicial intervention is much more limited, which also limits their possibility to award remedies that are actually effective in the context of consumer protection against unfair terms. So rigidity of the procedure is an important factor, and in Spain, in the Netherlands, there seems to be much more space for courts to interpret the rules, the procedural rules, in such a way that they can actually offer, to an extent, effective judicial protection that is required under EU law. A second procedural substantive factor, I'm not sure if it qualifies within one of these boxes, but would be the constitutional framework, that in Spain there is a monopoly of the Tribunal Constitucional that protects fundamental rights and constitutional rights in Spain, and that has up until recently been very restrictive or hesitant to apply EU law, which is for the normal courts to do, the ordinary courts to do. And in the Netherlands, we don't have constitutional review, so the ordinary courts are actually much more familiar already with constitutional reasoning, but also flexibility in application of the legal norms that govern the private relationships between the parties. So the legal factors, I think, those two are the most important ones. And then there have been also political, social, and economic factors that I do mention in my thesis, but are not the subject of my analysis as such, but I think play an important role in the background. And that is that the financial crisis in Spain seems to have hit much harder, or in any case seems to have much more harsh effect for consumer debtors. And especially there, you see the impact of the Court of Justice case law, where the courts did not have the space to provide protection. And in the Netherlands, this seems to have had, in any case, in terms of scale, a different impact. That might explain actually why we see so many more preliminary references from Spain, because it was a response, so to speak, to the financial crisis. And in the Netherlands, much less so, because it was solved within the system, or courts could find solutions within the system. I think those are the three main reasons that I have identified, because Article 47 is mainly a procedural provision. It refers to procedural justice, procedural safeguards, many substantive factors would fall outside the scope of my research, because both the directive has been implemented in both the Netherlands and Spain in the private law framework. So I haven't really looked specifically at the substantive consumer protection factors, but those seem to have played much less of a role in terms of impact of the Court of Justice case law and numbers of preliminary references. I hope that answers your question.
How do you draw the boundaries between procedural and substantive dimension? It's a positive question because it's based on the ways in which legal systems draw these boundaries, but it is also an EU issue. So, so you said that in your thesis you focused on the procedural because substantive dimension has already been dealt with by other. But clearly, you had to come up with a theoretical, conceptual distinction to be able to isolate the procedural from the substantive. What was your take on that? And did you change your perspective alongside drafting your thesis? That is to say, the procedural dimension increased or decreased while you were writing your thesis?
Thank you very much for this follow-up question. This is of course an important distinction, not so much perhaps from the Court of Justice perspective, because that is primarily concerned with the effectiveness of the directive, and there the procedural and the substantive elements are inextricably linked. But on the national level, you do see a difference in the kind of questions that are being asked, not only to the Court of Justice, but also that come up in the domestic case law, between the actual substantive assessment and the substantive application of the norms. So, for example, is there an unfair term? Is there a consumer? Does this party qualify as a consumer? How should we apply Articles 3 and 4 of the directive, the unfairness assessment, so to speak, and the consequences of it. So the private law consequences between the parties, for example, restitution and other, so the consequences of the non-bindingness of unfair terms. And the possibility of making such an assessment possible. So actually bringing the case before the court, which has to be done by one of the parties. And in many of these cases, it is actually the professional party who is interested in debt collection that brings a case before the court. So there are many default proceedings. And then the role of the court in actually being able to make that assessment. So not how it makes the assessment, but that it can make the assessment in the first place. So to speak, the preconditions for bringing a case before the court. And this is very clear in the context of access to court, so procedural obstacles that might prevent or deter primarily consumers from raising objections or bringing a case to the court. It becomes a little bit more blurred if you start looking at the scope for judicial intervention and the ambit of the dispute. But both in the Netherlands and Spain, at least, there are clear rules, or there's a lot of debate about these rules, but they are implemented in the Code of Civil Procedure. So there you really see that those countries themselves qualify them as procedural. And that really ties in with also what you see in the Court of Justice case law on Article 47, which is very much about the procedural guarantees. So for the court to being actually able to give a remedy or to be able to give an assessment of the legal relationship.
Yeah, but let me push you a little bit farther on this. So let's take a concrete example, burden of proof. If you were to describe whether this is substantive or procedural, or maybe both, but when it is one, when it is the other, what kind of criteria would you use? And don't you think that in Spain and the Netherlands, the definition of whether burden of proof is a procedural or a substantive changes, and so you can't really have one single criterion to evaluate that. So when the Court of Justice delivers a judgment, whether or not in the member state burden of proof is a procedural substantive dimension changes from one to the other. So again, what is your criterion to make that distinction? To what extent do you think there is consistency or inconsistency among member states in defining burden of proof a substantive or procedural dimension, and what kind of impact that difference might have had on the way the Court of Justice has had an impact on the case law?
May I ask you to keep the answer a bit short?
Yes. Let me then suffice by saying that from the perspective of my research, the distinction between substantive and procedural is not as clear-cut, and Article 47 can actually influence both, and especially with burden of proof, which you rightly point out is on the borderline, actually, I would say, of substantive and procedural. But it seems to be that the application of Article 47 is really reserved for the procedural side of things. So I haven't found cases that on burden of proof where Article 47 is being referred to.
Okay.
Thank you.
The opposition will now be continued by Professor Esther Arroyo. She is a professor of civil law at the University of Barcelona. And a warm welcome to you as well. The floor is yours.
Thank you very much, Mr. President. It's really a pleasure, and more than a pleasure, it's an honor to take part in this academic event where we meet in order to assess Anna van Dam's doctoral thesis. To be more precise, I would say that we met in order to celebrate a great effort that has produced excellent results. Dear candidate, you have done a huge work and a magnificent thesis that cleverly illustrates the role civil courts play in European private law adjudication. The thesis correctly formulates the area of study and the problems you want to address. Your objectives are clear, your language is precise, and your arguments are really rigorous. And from the very beginning, you explained very well the type of research you want to carry out. I'm really impressed on how theory and practice are accurately matched in your work. And I have to mention especially how carefully you deal in the chapter, you deal with the Spanish law in a whole chapter. It has really been extraordinarily well worked out. I therefore appreciate very much your research, and I warmly congratulate you and your thesis supervisors as well. I don't really have objections to your research, from which I have learned so much, so therefore I would dare to ask you your opinion on the possible application of Article 47 of the Charter in a hypothetical case that maybe could arise in the future in Spain. As you know, default interest rate clauses in mortgage credits have always been very problematic in Spain. Leaving details apart, I just want to point out that the law in force until very recently just set a cap, and therefore each judge did understand in his own way, depending on the specific case, what was to be considered an unfair default interest rate. The fact is that this generated uncertainty, and very recently the legislator has replaced this regime with a clear and fixed quantity. From now on, the amount of default interest rate is excluded from party autonomy, and currently the law sets the amount without even the possibility of agreeing on a lower quantity in order, I insist, to prevent terms that might be unfair. It is well known, and you know it much better than I, that terms reflecting mandatory provisions are excluded from the scope of the directive on unfair terms, because it can be presumed that these rules reflect a balance between the parties' rights and obligations. However, it seems clear to me that the Spanish rule is expressly designed to circumvent the application of the directive, because it does not allow the consumer to challenge the unfairness of default interest rates, even if the new interest rate that is being now imposed by the new rule is higher than the previous one that may have been declared unfair. This, of course, reduces the level of consumer protection, and the question I would like to ask you, finally, is whether the right to effective judicial protection of Article 47 of the Charter can be used to extend the scope of judicial intervention, or said it in other words, could a judge, ex officio or not, that would be another question, could a judge declare that this mandatory rule is contrary to the consumer right of access to justice? Which color may Article 47 of the Charter adopt in such a case? Thank you very much.
Highly esteemed opponent, thank you very much for your kind words about my thesis and the research I have conducted. I have indeed spent a lot of time trying to understand Spanish law, both substantively and procedurally, and the impact it has on the effective judicial protection of consumers. And one of the main things that struck me, and I also tried to describe in my Spanish chapter, chapter 4 of the book, is this interaction between the courts, the legislature, and the Court of Justice. And there seems to be a circle going on of questions, implementation, more questions, and there just doesn't seem to come an end to it anytime soon. And it's interesting that this unfair default interest rate is yet another example of this, the discussion that continues. So I would be very interested in hearing the different interpretations of lower courts in Spain, actually. But your question pertains to the fact that the Spanish legislature has decided to fix this interest rate in a statutory provision, which under Article 1.2 of the directive would mean it's excluded from the scope of the directive, which would also automatically put it outside the scope of, well, in any case, of EU law, and possibly also the scope of application of Article 47. In my book, in chapter 3, I refer to the Hungarian cases that had a similar problem about foreign currencies, where in response to Court of Justice case law, the Hungarian legislator also adopted legislation fixing the foreign interest rates, or the currency, the exchange rates. And there was also a debate there whether this meant that they were now removed from the scope of judicial review. Not necessarily ex officio, I agree with you that that's a different question, but in the first place, if the court can actually say something about the unfairness of these rates. And there you see that the Court of Justice, this maybe refers back to the previous question of Professor Cavacci, the distinction between substantive and procedural becomes a little bit blurred, because the Court of Justice is very strict in saying procedural rules serving to ensure that the rights of consumers under the directive are respected. They are always within the scope of judicial review, so Article 1.2 should be strictly construed, and you cannot say just by the fact that they are now in legislation, they're now excluded from the scope of the directive. But the Advocate General, in specifically the case OTP Bank, I'm not sure what the correct Hungarian pronunciation is, but he went a step further, Tanchev, and said that also if it's a substantive provision, so the foreign currency rates, it cannot be excluded from the scope of the directive because it is a response to the Court of Justice case law. And if we would exclude this from the scope, it would make it immune from judicial review. And that's problematic from the perspective of, well, he refers to Article 47, but largely parallel to the principle of effectiveness. But I think you could go a step further and say that this goes actually against Article 47 as well. In my book, I refer to the strengthening and empowering function of Article 47 in this respect. So both for consumers to invoke Article 47 here and say, I should be able to challenge these interest rates because otherwise they're immune from judicial review, but also from the perspective of the courts, and that was your question, I believe, that the Spanish courts should be able, or in my view, they should be able to refer to Article 47 in this respect and say, we cannot be bypassed or circumvented by reference merely to Article 1.2 of the directive when this is an implementation of Court of Justice case law. And I think a second argument is also that the Court of Justice has always said that the court should have the freedom to assess these interest rates. And this is more a substantive issue, so not necessarily Article 47, but especially if they're higher than the previous interest rates. Or it says that the court cannot even assess if they're lower, if they're unfair. That actually limits it in such a way that I would even say the procedural guarantees of the directive are at stake. So I have a very strong view on this, but it really depends on how the Spanish courts see this and if they will make a reference to Court of Justice. Yeah, I hope that answers your question.
Thank you. In view of the time, we proceed to the next opponent. So I invite Professor De Bok, Professor of Civil Education at Civil Adjudication at this university, and Advocate General at the Dutch Supreme Court. Professor De Bok.
Thank you. Dear candidates, first of all, I would like to congratulate you on the fine thesis you have written. Your dissertation is devoted to an important topic that has received little attention until now, and it's also very clear and insightful. One of the findings of the investigation is that the role of Article 47 in Dutch case law is limited. It is often assumed that Article 47 is in fact interchangeable with Article 6 ACHR and has no added value in relation to it. If I see it correctly, but I like to know if it's different, you do not dispute that when it comes to, for example, the right to defense or the principle of equality of arms, we get along with Article 6. But it's otherwise for the right to an effective legal remedy and access to justice. In your opinion, Article 47 does have added value on those aspects. What strikes me in your discussion of Dutch case law is that little attention is paid to judgments where no explicit reference is found to the concept of effective remedy as such, but in which the chosen solution does contribute to this. For example, I'm thinking of solutions under evidence law, such as the reversal law, presumptions of evidence, and duties to disclose information. Or when it comes to access to justice, the settled case law that a mere claim of having an interest is sufficient to gain access to justice. Neither you give consideration to solutions in substantive law, such as relaxation of limitation periods. I would therefore like to ask you the following questions. When it comes to whether Dutch case law would benefit from a greater role for Article 47, should it not have been more widely examined how justice is done to the principles of effective remedy and access to justice? And would in that case the outcome still be that Article 47 has added value? And finally, could it be, and then I'm following one of your own suggestions, that this added value mainly consists in removing the financial barriers to litigate? And if you do think so, has the judge a role in this?
highly esteemed opponent, thank you as well for your kind words about my thesis. And your question is actually refers to a dilemma I was faced when I was defining the scope of my research and how deep and how far I would go into the two legal systems that I examined, because for Dutch law, my knowledge of Dutch law in general, but also civil procedure specifically, is much broader and wider than for Spanish than for the Spanish legal system. So it was, to a large extent, a methodological decision to delimit it to explicit references, but I have also looked at references to the principle of effectiveness and, in general, the debate on of consumer protection and what the role of the courts should be in this respect. You summarized correctly that I don't see major problems in terms of, well, the right to be heard and the autonomous procedural safeguards that Article 47 contains. Also because we have Article 6 and the traditional principles of civil procedure that Dutch judges seem to be very aware of and very conscious of, so there are no major problems there. And this is also what I refer to in my answer to question 1, that I see that Dutch judges have a lot more space, but also a lot more awareness of how they should apply the rules in such a way that effective judicial protection is achieved in this context for consumers against unfair terms. However, despite the many different topics that Article 47 could be relevant to, so prescription is one that I briefly mentioned on page 232 of my book, but it is true that the burden of proof I don't pay specific attention to, again, because I don't see any issues up front from the perspective of Article 47 with this. That there are many different topics that could potentially be affected by Article 47, and that they don't has, I think, to do with the factors that you mentioned earlier, that courts have other ways of implementation. But I still think we can learn some lessons from the Spanish case law and the Court of Justice case law. And the first is that Article 47 really has persuasive authority as to the rationale of effective judicial protection. It is not just ex officio control, where we have, of course, the reports since I should say it correctly, but 2014-18 in any case, but 2010 I think was the first one, where there's a lot of attention for ex officio control, but less so the access to court dimension of it. And I think cost is exactly an example where you see that Article 47 could have persuasive authority in any case for courts to be more aware of the barriers that this creates and their discretion to award cost orders or to at least be conscious of the barrier this creates. And in Spain, actually, there are references to the Court of Justice to create this space in the first place so that the procedural rules become less strict. I think Dutch courts already have more discretion there. So this is one example that I can think of. And the other one is the judicial review of arbitration clauses, where we've had, of course, a huge debate triggered by debt collection in consumer cases, where there was a strong awareness about, well, the ex officio dimension of this, but maybe less so the fundamental right of access to court that was at stake here. And there have been some courts, and I refer to them in Chapter 5, that have actually recognized this dimension and refer to Article 47 even in that respect. But I still was missing this a little bit from the debate about really the fundamental role of courts, the due process dimension, the public dimension, the rule of law dimension here at stake. Not only procedural guarantees, but also the application of national and EU law, that it must be ensured and that it's applied correctly by the courts. So yes, they definitely have a role here. And I think those are the two main points of improvement, is maybe even too strongly expressed, but points of awareness for future debate on these issues.
Okay,
I hope
thank
that
you
answers
very
your
much
question.
for this clear answer.
The opposition will be continued by Professor Van Hoek, Professor of Private International Law at this university and Professor of Civil Procedure at this university. Professor Van Hoek.
Dear candidate, it's a great pleasure that I stand here to question you on your thesis. You took on a hell of a job, comparing the impact of the Charter on judgments in 3 legal systems. This means you had to make hard choices, and you did. Reading the first chapters, I repeatedly heard myself say, but, ready to object to some of the choices you made, only to find out a couple of pages later that you perfectly explained them. So, compliments. It was a bit like you already knew where my objections would fall, which wouldn't surprise me anyways, because we know each other quite well in a lot of respects. So compliments on the work, but I'm not here to just give compliments. I'm here to make life difficult again, once more, and I'll try to do it a bit. I had 3 different questions linking to questions already put by some of the other people. That's basically one of the disadvantages of being the almost final one to intervene. But I will take question 1, and that's on method. Yeah? Your analysis is based on case studies, on court cases in the EU, Spain, and the Netherlands. And this approach, which is actually quite common for a legal study, does pose challenges and risks. And one of these is case selection and comparability, especially in this combination. And my questions relate to this issue. And there's some elements I want to put forward and ask you how they affect the comparability of your results, and also to challenge you on the issue whether in this case comparability would actually matter. So are the sets comparable, and does that matter? And the one is, how did you actually find your cases? Because usually we tend to use databases, but I know from the Dutch database how they select the cases, and it's a minority of cases that finds their way into the public database. So can you explain a bit on the comparison between the Spanish cases and the Dutch cases in this respect? Another element is Spain is a very big country and they have a lot of cases. The Netherlands is much smaller and we had hardly any. So you decided to broaden your scope a bit in the Dutch case. How does that impact the comparability of the results? And the last issue, you basically focus, given the question you pose, on court cases. Yeah? That means you miss out on everything that doesn't come to court. Mm-hmm. And that, of course, is from the perspective of the Dutch system relevant, because in the Netherlands you can enforce a mortgage debt without having to go to court. So how does that impact your findings? I can see you already thought about this.
Thank you very much, highly esteemed opponent, for these questions, or rather maybe objections to, delimitations to the comparison that I was able to make between the Netherlands and Spain. The short answer would be yes, of course, they affect the comparability, and I've tried to be conscious of that in the book and say where I was actually deviating from the delimitation that I mentioned earlier, for example, in the Dutch cases, where I broaden the scope a little bit. But from an EU law perspective, it should not matter, or you read a lot in the literature about Article 47, it should not matter which country you look at, because it's all binding. Article 47 has direct effect. It should all be implemented in the same ways. So as soon as you start looking at the ways it's being implemented at the national level, and you start seeing divergences, it already becomes very difficult to compare. But I'm not sure if it matters from an EU law perspective, because as soon as you identify procedural obstacles or limitations to the scope of judicial intervention, it may become an EU law issue. But a very valid question that is, of course, the finding of the cases. Let's start with that one, because as a researcher, I was dependent on the databases. I had to use rechtspraak.nl for the Dutch case law, and I had to use, or I made the choice to use Aranzadi for the Spanish cases, because it seemed to just bring up more cases. It seemed to be more complete than some of the other case law databases that I found. But this is indeed a methodological limitation that I'm very much aware of, and that should maybe make me a little bit more conscious about how much I can say about or how broad my conclusions are applicable. The same applies to the focus on court cases, because what doesn't come to court, of course, you don't see. The courts don't see it, but I, as a researcher, don't see it either. And I identify actually the specific problem of the mortgage enforcement in Dutch cases in the Dutch chapter, that Dutch courts don't seem to do it. And this would be very interesting for follow-up research that Professor Pavillon, we've already exchanged some thoughts on this specific topic that I think would be very interesting to explore further. Why it doesn't happen, whether it should happen. It seems so from the Spanish case law, but it also, again, really depends on how it's implemented in the Dutch system, and that there seem to be other safeguards in place that achieve the same result. So this is a big difference between the Spain and the Netherlands in terms of the case selection, so the case that you can actually say something about as a researcher. Spain is indeed a very big country with a very different political, social environment. And what I found interesting is that whilst from an EU law perspective maybe this shouldn't matter, the court cases really indicate that it does. It really influences not only the legal application of the rules, but also the way the courts look at it, the position they take vis-à-vis the legislature. And I have identified these, well, broader perspectives in my national chapters, but this would also be really something for follow-up research, maybe to go and talk to the judges and interview them on how they perceive their role and if my findings actually reflect what they also see in their daily practice. Or maybe even go and talk to lawyers, which cases go to court and which don't, and what this actually says about maybe the lack of effective judicial protection in the dimension that we don't see in the court cases. So again, thank you very much. I've been making notes, and I think these are all very valid points and interesting topics for further research.
Okay, thank you very much. Happy with the answer.
Thank you. The opposition will now be continued by Professor Loos, Professor of Private Law, in particular European Consumer Law at this university. Professor Loos, the floor is yours. Professor Loos, we cannot hear you. Perhaps you should unmute.
I have unmuted.
Yes,
so.
now we hear you.
Thank you, Mr. Rector. Dear candidate, I am sorry actually that I'm not in Amsterdam but in Haarlem, so I cannot address you in person. But from Haarlem, I hope my voice reaches at least the rooms there in Amsterdam. I was very pleased in receiving your PhD thesis. I've read it with great enthusiasm, and as this book clearly is a success, I am proud to be the grandfather of your PhD, as I basically borrow from one of your paronyms, that analogy. My question basically deals with something you write on the bottom of page 216 and the top of page 217, and I will quote that text. It follows from the court's case law that the position of consumers as weaker parties must be taken into consideration from a procedural perspective as well. For instance, it could be argued that in consumer cases, the deterrent effect of costs should also be accounted for, and that ex officio control cannot, at least not fully, compensate for this. If no legal action is brought, the case does not come before a court. That sounds logical, of course, but does this not mean that it is the legislator who is required to act and not the court? And of course, the state may be liable if the legislator does not perform that task, but then again, this only gives the court an opportunity to act or to react if a case is actually brought before that court. So isn't this actually a paper tiger then? Does Article 47 of the Charter really bring us anything new here to combat the deterrent effect of costs? I'm curious to hear what you think of this.
Highly esteemed opponent, thank you very much for this question and your kind words. And I'm happy that you could still join us from Haarlem, which is actually not too far away from where we are right now. This specific section that you quote on page 216 to 17 indeed refers to the point of cost that Professor De Bok also referred to in her question. which is a very topical issue, at least in the Netherlands, but also in Spain. There are several preliminary references to the Court of Justice about this, because it's obvious that it may have a deterrent effect on consumers to bring their case to court or to raise their objections. And then your question is, if I understand it correctly, whose role is it to address this issue? Because you could say that it's actually for the legislature in any case to set the court fees or address the issue of court fees. But I think it's also broader that you actually see that also, well, the fees of lawyers can have deterrent effects. So cost is a very general container term actually for a procedural obstacle that can apply to consumers. And what I refer to in my research as the signaling function of Article 47 is that I really see a potential role here for courts, but also for Article 47 to, in any case, contribute to the visibility of these procedural obstacles. So whilst they may not be able to, or may not be willing or hesitant in any case to disapply, for example, procedural rules about costs, they may actually, in their decision, use Article 47 as some kind of a signal to say, in this specific case, or on a systemic level, we see that this is a problem for cases coming before the court. So a lot of cases we don't see because of this issue. And one of the decisions I discuss, I think a little bit earlier in the same chapter, is not in the consumer sphere, but in the sphere of data protection, where the Hof den Bosch has actually done this. So they have referred to Article 47 and the Court of Justice case law, saying, one, we're using here our discretion not to issue a court order to the detriment of the subject exercising its EU rights, because you should be able to exercise your EU rights, and we're signaling to this specific party that they should not be prevented from coming to us by and invoking their rights here. And secondly, this may also contribute, but this is of course hard to measure for a researcher, to some kind of a call for action to the legislature, a trigger perhaps, which may lead to a transformative function of Article 47, to signal to the legislature that this is an issue. And of course there are other ways to do this, like the societal debate that we have on the issues of cost. There is some action in any case from the Dutch legislature on cost and making it actually more accessible to consumers. But yes, I do see a role for the courts here. And I think the case from the Hof den Bosch is a very clear example of how they could do this. There is actually a case from Spain, and very recent decision from the Court of Justice on costs, where the reference to the Court of Justice has had the same signaling effect, and a reference to Article 47 on the costs for consumers, and where the Court of Justice has indeed said this can be, there was no English translation available, so the Dutch is aanzienlijk obstakel, so I would say it can be an excessive obstacle or a big obstacle. And that the court should actually, in the application of these rules, take this into consideration with reference to Profi-credit and other case law on Article 47. So it's an interesting development that I think we haven't seen the last parts of.
Just to check, was the answer finished, or do you
I hope that answers your question. Yeah, it was just about finished.
Thank you so much. Hiermee is een einde gekomen aan de periode van verdediging en oppositie. En ik verzoek u nu om het tweede gedeelte van het formulier voor te lezen.
Na de verdediging van mijn proefschrift naar vermogen te hebben volbracht en in afwachting van het oordeel van de promotiecommissie, stel ik er prijs op mijn oprechte dank te betuigen, in het bijzonder aan mijn hooggeschatte promotores, als ook aan hen die zo heuselijk hun bedenkingen hebben voorgedragen en aan u allen die deze plechtigheid met uw tegenwoordigheid hebt willen vereren.
De commissie trekt zich nu terug voor beraad.
so typical. So typical.
Oh my God, I just put on.
But I'm glad you get the example. I saw that coming.
Mevrouw de doctorandus, we hebben kennis genomen van het door u bewerkte proefschrift. We hebben de inhoud voortreffelijk bevonden. En op grond hiervan hebben wij besloten u het doctoraat te verlenen, cum laude. De hoogleraar Mak is gemachtigd u op de gebruikelijke wijze met deze waardigheid te bekleden.
Sorry, eerst het formulier. Volgaarne aanvaard ik de taak mij door de rector magnificus der universiteit opgedragen. Uit kracht dan van de bevoegdheid ons bij de wet toegekend, volgens het besluit van rector en college voor promoties van de Universiteit van Amsterdam, verklaar ik bij deze u, Johanna Maria Leuntje van Duin, te bevorderen tot doctor en u alle rechten te verlenen die door de wet of gewoonte aan het doctoraat zijn verbonden. Ten bewijze hiervan zo u het diploma door rector en promotor ondertekend en met het grootzegel der universiteit bevestigd ter hand worden gesteld. Nadat ik alzo de mij opgelegde taak heb volbracht, mag ik de eerste zijn die u als dokter begroet en met de zo loffelijk verkregen waardigheid geluk wenst.
Mag gaan zitten.
Dear Dr. Van Duin, dear Anna, congratulations on your excellent book and on defending it so well today. It is a perfect ending of a journey that started almost 5 years ago with your application for a Ph.D. position in the Judges in Utopia project. Or an almost perfect ending, but we will get to that. In January 2015, you applied for a Ph.D. position at the UvA. You opened your application letter with the first line of Joseph Heller's Catch-22, which, you explained to me later, is one of your favorite novels. It was love at first sight, you wrote, of the Judges in Utopia project. Your choice to apply for a PhD position was a brave one, as it meant giving up a career in legal practice in which you had already built up 6 years of experience in a law firm. While it is not unusual for people who obtain a PhD in private law to switch to practice, the opposite is much rarer. During the application procedure, accordingly, the selection committee questioned you quite extensively about this choice, and you managed to convince us that this was really what you wanted. That both you and the committee had made the right decision became clear quite soon. For me, this was already before you officially started. The PhD trajectory started in September 2015. In June of that year, however, an important conference on the topic of fundamental rights in private law took place in Oxford. I invited you and Lara Burgers, who is also here today, to join for that conference. Our flight was delayed and it was long past the normal dinner time when we finally reached Oxford. Since you had studied there some time before, you told us not to worry, and within 5 minutes you had found us a restaurant, and within 15 minutes there was some nice Italian food on the table. So that was an excellent start. Your efficient and caring nature further demonstrated itself once you started the PhD project in September 2015. By then, Joasja Luzak had become your second supervisor, and you began developing your research plan. It would be about the role of Article 47 in private legal cases, but the precise focus still had to be defined. You put so much energy in this part of the process that Joasja and I sometimes had to remind you that you had a further 3 years to develop the project. Eventually, he decided to focus on the Unfair Terms Directive. This would allow you to study the functions of Article 47 in depth, and moreover, you could make a comparative study of the Netherlands and of Spain, since you knew Spanish. This turned out to be a great advantage, as you managed to obtain insights into the background of important Spanish cases that were referred to the Court of Justice of the European Union. The work on Spanish case law also led you to Barcelona, where you created connections with scholars there, including Esther, Gemma, and Rosa. While your research stay in Barcelona was certainly beneficial to your project, it was also one of the few phases in which you found it sometimes difficult to see the way ahead for your project. Although Joasja and I had regular Skype calls with you, being away from the Netherlands meant that you had to rely on your own views about the project. In the end, as we have seen, this all worked out, and it led you to the distinction of different functions of Article 47 that became the core of your thesis. In the meantime, also other colleagues had begun to see your talents. You collaborated on 2 international projects on judicial training, Actionis and Reus, with Fabrizio and his colleagues in Italy. Moreover, more and more colleagues in Amsterdam started to ask you to co-teach and co-organize classes and seminars. At a certain point, I even had to discourage colleagues from asking you to do more work. Moving to Amsterdam, moreover, contributed to your further integration in the group. It also seemed to have its effects on you, perhaps most visibly when you had your hair dyed pink. Having thought this through, Anna always thinks everything through very well, you had picked the end of the teaching block before Christmas for this, so it would go unnoticed by the students. Since you have moved to Amsterdam, we also saw more of Jesus, who was adopted by our research group as a designer of the new logo for the Amsterdam Center for Transformative Private Law. Perhaps even more importantly, Jesus relativizes the importance of Article 47. Why not Article 46 or 48? And I'm very happy for both of you that you have concluded the project in such a good way. As said, an almost perfect ending. One thing that we miss though here is the presence of Joasja, who could not travel to Amsterdam. Luckily, she was able to join online from Exeter, and she would also like to say a few words to you. Joasja, the floor is yours. Oh, we cannot hear you.
Okay.
Yes, we
I
can
am
hear
not.
you.
Yeah? Okay, dear Dr. Van Daan, dear Anna, what a pleasure it has been to supervise you on your journey to this achievement. You never really believed us, Chantal and me, when we were assuring you that it was easy to work with you and that you were doing a great job. I hope today finally solidifies the following with you. You are an outstanding scholar, and even greater things are ahead of you. This is just the beginning. But instead of looking at the future, I want to look back. And to keep with being organized and structured, which all 3 of us, me, Chantal, and Anna, enjoy, I made a few Stellingen about Anna. Whilst I won't be able to see the reaction of the audience to them, I hope to hear from Anna's parents, Jesus, and other family and friends, whether they think I hit the mark with the Stellingen. Stelling number 1. Anna appreciates and needs supervision, provided she can supervise her supervisor. A proof of Anna's strong presence was not difficult to find for me. I found the following email from her from August 2015, which was a month before she started her position with us. Zoals beloofd stuur ik hierbij een overzicht van de dagen waarop wij bij elkaar gaan zitten. Het gaat dan op de volgende dagen. 2 september, 23 september, 14 oktober, 4 november, 25 november. Mochten jullie verhinderd zijn op een van deze dagen, dan kunnen we misschien uitwijken naar een andere dag op week. Joasja gaf aan dat zij vanaf 10 december met vakantie is. Zou het een idee zijn om ook alvast een datum in de eerste of tweede week van december vast te leggen? To sum this up in English, even before she started working with us, Anna was telling us what and when to do it, not the other way around, but she graciously made leeway in her planning for our own too. Stelling number 2. Anna is both a perfectionist planner and a spontaneous, impatient creator. This seeming conflict leads to brilliance on many occasions. Just read her book as proof or invite yourself last minute to one of her parties. But it can also cause some trouble. The first hint thereof came when she was finalizing a chapter. Instead of submitting a first draft, she would submit a first draft of a first draft with plenty of disclaimers to go with it, such as, and I'm quoting, "The chapter still needs a lot of drafting and redrafting, but it's getting shape. I'm already planning the next chapter." Her perfectionist side demanded that she keeps working on this according to her work in progress chapter. The creative side presented to her already all the ideas for the chapter to follow. And as she has also told me, since patience is something she doesn't have much of, as much as she wanted to continue working on that imperfect according to her chapter, she also wanted to move on with things simultaneously. This was at times frustrating, especially since as supervisors we could see progress while Anna felt stuck. Luckily, mostly Anna did not hesitate to reach out to us in these moments. Stelling number 3. Anna's creativity tends to spike on the weekend. I received many messages from Anna on Sunday afternoons asking for a clarification or a motivation talk. But when I was looking back through our messages, I also found this, and I'm quoting, "I desperately need to discuss an urgent question. What would you think this was related to? The link between the UCTD framework and Article 47 of the Charter? No. The desperate need to discuss this urgent question was in this case related to a Game of Thrones plot twist. Which leads me to the following stelling. Stelling number 4. Any supervisors of Anna have to know how to have fun with her. And that we did. We were in Amsterdam, Exeter, where she visited me at a random afternoon in Warsaw, finding a place that served killer shots with Tabasco involved. Although I needed to delegate it to my partner to face her in a dance-off in the Dutch Haber style. I think that was a draw. Stelling number 5, the last one. Anna keeps people around her on their toes. At times I would send Anna a link to an article I would think would be useful for her, only to hear back that she has already included it in her bibliography. When I managed to find something that she has not yet thought about or read, that was a personal success. Anna, we went through some struggles together, and I do not mean here only the hot sauce challenge, which I pretty much bowed out of. It was not all easy come, but that also means it won't easily go away. Trust yourself, but rely on others, not just Chantal and me as well. I hope we will remain your to-go-to persons in case of any queries. We are proud of you. As they would say it in my current country of residence, congratulations and carry on.
Thanks so much, Jascha. I now have to read the final part of the formula. Waardeer de verkregen waardigheid als een eervolle onderscheiding, een gewichtig voorrecht en vergeet dan ook nooit de verplichtingen die zij u oplegt jegens de wetenschap en de samenleving.
Ik kwijt mij van een zeer aangename plicht, zeer geleerde vrouwen, door u ook namens het College voor Promoties van de Universiteit van Amsterdam met de verworven eer geluk te wensen. En hiermee verklaar ik deze plechtigheid voor beëindigd. Volgens mij is het een moment voor applaus.